Law is a set of made by the government that must be followed by everyone to maintain order and justice in society. In Malaysia, law is classified into sub-type. Public law deal with the relationship between the government and the people, such as constitutional law and criminal law. Private law deal with relationship between individuals, for example, contract and family law. There are also civil law for compensation, criminal law for the punishment, as well as written and unwritten law. The main source of law in Malaysia is federal constitution, which is the higher law in the country. Other sources include law made by parliament and state legislative assemblies. Judicial precedents mean lower court must follow decision made by higher court. English law is used under Civil Law Act 1946 when there are no local law. Islamic law and customary law are also import source of law in Malaysia. The superior court are the higher court in Malaysia. There are 3 levels, which are the High Court, the Court of Appeal, and the Federal Court. The higher court hears serious civil and criminal case and appeal from lower court. The Court of Appeal hears appeal from the higher court only. The Federal Court is the higher court and decision final appeal an important constitutional matter.
Hello, good morning everyone. Today I want to talk about the subordinate courts in Malaysia. In Malaysia, the subordinate courts are below the High Court. There are 2 main types, which are the Session Court and the Magistrate Court. The Session Court handles serious criminal assets except death penalty cases. It also handles civil cases involving money up to 1 million ringgit. The Magistrate Court handles smaller criminal and civil cases. These courts are important because they deal with many cases every day. Thank you. The business must be registered with SSM. Next, the franchisor must prepare important documents like the franchise agreement. After that, the franchise must be registered with the Register for Franchise under KPDN. No franchise can be offered before approval. Once approved, the franchisor and franchisee sign the agreement and the business operation can start. Liability means one party is responsible for the wrong action of another party. This usually happens when there is control, like employer and employee. In franchise business, a franchisee is usually independent, not an employee. However, if the franchisor has strong control, they may still be responsible. This concept helps protect customers and encourage good business practice.
Next, explain the definition of classification of a company. The definition of a company is can own property. Company can enter into contract. Company also can sue and be sued in its own name. Next, classification of companies. First, private company, Sendirian Berhad, maximum of 50 shareholders, restriction on transfer of shares, limited liability, and most common type of company in Malaysia. Second is public company. It's Berhad. Shares can be offered to the public, may be listed on Bursa Malaysia, subject to stricter regulation, suitable for large-scale business. Next, company limited by shares. Liability limited to unpaid amount on shares, common for commercial and profit-making business. Company limited by guarantee. No share capital. Member guarantee a fixed amount upon winding up. Usually formed for non-governmental organization. Charities Association. So next is procedure of termination of franchise in Malaysia. First, law governing franchise termination. The process of terminating a franchise in Malaysia is governed by the Franchise Act 1998. This act provides for fairness and protection for both parties, the franchisor and the franchisee. It also arbitrary or unjust termination. Grounds for termination: a franchisor may terminate a franchise agreement if the franchisee commit a breach such as failure to pay franchise fees or royalties, failure to comply with standard operating procedure, misuse of trademark or brand name, and involved in illegal or unlawful activities. Written notice requirement is franchisor must issue a written notice to the franchisee. So the notice must state the failure, state the nature of the breach, express intention to terminate the franchise agreement. For remedy period, franchisee must be given an opportunity to remedy the breach. Reasonable period provided, minimum 14 days. If the breach is remedied within the period, termination is not allowed. Next, termination of franchise agreement. If the franchise fails to remedy the breach within the given period, franchisor may terminate the agreement. Termination must comply with Franchise Act 1998. Follow the franchise contract. Lastly, post termination obligation. After termination, the franchisee must stop using the franchise name and logo, return confidential information, and settle outstanding debt or fees.
Hello, today I will talk about the procedure of the formation of a company in Malaysia. Forming a company in Malaysia starts with deciding the type of company, usually a private limited company or sendirian berhad. You need at least one director and one shareholder, with the director residing in Malaysia. Next, decide the nature of your business and the company name. Once decided, conduct a name search with the Companies Commission of Malaysia or SSM to ensure the name is unique, not misleading, and complies with regulations. If approved, the name is reserved for a limited period. Then prepare the incorporation documents, including details of directors, shareholders, registered office, business type, share capital, and optionally the company constitution. Submit the application online via SSM, which will review for legal compliance and completeness. If approved, SSM issues a certificate of incorporation confirming your company is a separate legal entity and can start operations. After incorporation, you must open a company bank account, appoint a company secretary, maintain company records, file annual returns, and comply with tax and licensing requirements. Non-compliance may lead to legal consequences. That's all for me.
Hello, today I will talk about the differences between company law, partnership law, and sole proprietorship. In Malaysia, businesses can be structured as a company, partnership, or sole proprietorship, each governed by different laws. A company is governed by the Companies Act 2016 and administered by SSM. It is a separate legal entity, meaning it can own property, and shareholders have limited liability, which is their risk is limited to their investment. A partnership. Under the Partnership Act 1961 is formed by two or more people to run a business and share profits. Partners have unlimited liability, share management duties, and the action of one partner can legally bind the others. And the last but not least, a sole proprietorship is the simplest form, owned and managed by one person, regulated by the Registration of Businesses Act 1956. The owner has full control and keeps all profits, but also has unlimited personal liability, bearing all business risks. That's all from me. Thank you.